State of Florida. That must have been a public case.
May it please the court.
Let's let the court get a little quieter here. Please proceed.
May it please the court. My name is Glenn Gifford. I'm with the Second Circuit Public Defender's Office here representing Mr. Knight. This case is before the court on two issues. One is a certified question on waiver of error under this court's decision in Williams. The second is a certified conflict on the harmlessness of the error. I'm going to start and spend more of my time with the court's indulgence on the second issue because I think it's a bit more consequential. And immediately we confront the question of the pardon power. This is not a pardon power case, and I'll distinguish pardon power cases from cases that aren't. A pardon power case, an example would be a charge of robbery with a firearm. Under our laws, under our standard jury instructions, even if the only evidence is that the defendant possessed a firearm, the jury is still instructed on robbery with a weapon and strong-arm robbery, so that the jury can exercise its pardon power and find the defendant guilty of a lesser-included offense. Concrete facts like whether the defendant had a firearm, whether the burglary was of a dwelling rather than a structure, we instruct on the lessers so that the jury can have the opportunity to partially pardon the defendant by finding him guilty of a lesser-included offense. This is not that kind of case. The homicide statute is not that kind of statute. The jury has for it attempted first-degree murder, attempted second-degree murder, and attempted manslaughter. The difference between these three crimes is intent.
I want to hear this, but I do want to interrupt to ask that you do recognize that your theory here is contrary to Montgomery and all of the other the reasoning of all the cases that say that this kind of error is fundamental error, right?
No, Your Honor, I don't think it is.
Okay, go ahead.
In Montgomery, the court did say that the rationale for instructing was on the pardon power, but in subsequent cases, and this court has had plenty of them.
Can you name one?
Haygood, Griffin, Williams, the case that controls here.
But don't those cases fly in the face of what the court had said time after time after time in earlier cases about the pardon power?
The court has said that there was a rational basis for the jury, a correctly instructed jury, to find the defendant guilty of manslaughter or attempted manslaughter, and the error including intent sabotaged, undermined the jury's determination, the jury's choice between second-degree murder and manslaughter, or attempt in this case. The court has said that time and time again. And here there is certainly a rational basis for the jury, once it had rejected attempted premeditated murder, to find the defendant guilty of attempted manslaughter.
But if the evidence is clearly sufficient to support a conviction of second-degree murder, then I'm having a hard time understanding why it's not a jury pardon issue, because the jury is told that they're to return a verdict for the highest crime for which the state has proven every element beyond a reasonable doubt. And in almost every case that I've looked at, the real debate is this first-degree premeditated murder or is it second-degree murder? And that's usually what is being argued about, and then we get a second degree, which is clearly supported by the record, and that's where we are. How is that not a pardon power case?
The issue is not whether the record supports the crime of conviction. The issue is whether a correctly instructed jury could find the defendant guilty of the lesser included offense after rejecting attempted first-degree premeditated murder. There's a bigger difference between attempted premeditated murder and attempted second-degree murder than there is between attempted second-degree murder and attempted manslaughter. And second,
Well, but for the jury to have convicted of the lesser offense here, the jury would have had to have gone through the process of deciding that there was, that the defendant did not have a depraved mind, right?
yes, a reasonable
How
doubt.
on these facts could any rational jury make that determination?
Because the implement used was not designed as a weapon. It was not designed as a weapon. It was not a knife. It was not a firearm. And once the jury had
Well,
determined...
it's certainly pretty useful to do a lot of damage.
I understand, but once the jury had determined that the defendant did not have premeditated intent to kill, it's a hair's breadth between that and determining that the defendant had no intent to kill whatsoever, which the attempted manslaughter instruction sabotaged by including intent. And I think that's why this court...
But I'm still, I go back to my question about depraved mind. Given the facts here and this vicious attack, which I think there's no other way to describe it, that the record fully supports, how can a rational juror look at that and decide that the facts related to that attack are not indisputable evidence of a depraved mind?
Because non-lethal force was used, particularly in an attempt case. It's a close call between attempted second-degree murder and attempted manslaughter. The jury could conclude that, yes, death could have but did not result, but the defendant, because he did not use lethal force, because he did not use a knife or a gun, did not have a reckless indifference to human life.
Wasn't the undisputed medical testimony that the pipe would have had to have been used hard enough in order to have injured them to the point of death? Wasn't that the medical testimony, that it was used hard enough that it would have caused death?
These were not lethal injuries.
Didn't the doctor exactly testify to that? That the pipe was used with such force? Because you broke her internal eye. In other words, he hit her with the pipe such that it broke the internal eye, that to do that, you would have had to have done so with the kind of depraved mind that Chief Justice Kennedy is asking you about.
It's a horrible case. These are all
No,
horrible
I'm asking you
cases.
if this is undisputed facts. Isn't that what the doctor
You're right,
testified
Your Honor.
to?
Yes, Your Honor.
So how then, if that's undisputed, could, as Chief Justice Kennedy asked, and I have the same question, you have found a properly instructed jury found anything other than depraved, at least depraved mind?
This court has reached that conclusion in many cases with similar facts. Williams, which controls in this case, was a stabbing case. This was not a stabbing case. A knife was not used.
So I don't think anyone disputes that, but doesn't that necessarily mean that it's the pardon power? In other words, the jury is saying, despite that evidence, we believe for some other fundamental reason, non-evidence-based, that we are finding a lesser included offense.
No, a jury could have found that the defendant was not recklessly indifferent of human life. And in an attempt case, that's particularly the
Even
case.
where a defendant laid in wait for the victim in this case?
There was evidence that he lay in wait. There was also evidence that the jury could have concluded that he didn't lay in wait as well.
Well, isn't there evidence that not only did he lay in wait, but he violated a court order since he had an injunction placed against him mere hours before?
Yes, Your Honor. And yet, the jury found the defendant not guilty of attempted premeditated murder.
But he beat her in the head with a metal object with great force. Isn't that true?
As in many of these...
And that doesn't evidence indifference to human life? I understand you're representing your client and you've got the facts you've got, but I'm just struggling to understand this of how a rational person can look at it in that way.
I guess to reach your point, we would have to find, the jury would have to have thought that if he wanted to kill her, he would have. That's the bottom line. And that's what, basically what the jury would have to think. But I don't know that the facts support that in this particular case.
Because he was stopped, really. There was somebody who showed up, I think the victim's son,
Yeah.
who stopped the attack.
Right.
And he ran away. So, but for the victim's son appearing, because I believe the victim yelled out to him, there is no evidence to suggest that he wouldn't have done that.
I mean, one more strike might have killed her.
I understand that
Yeah, Mr.
if the court were the jury, that the court would have found the defendant guilty of attempted second-degree murder, but that's not the test. The test is whether a rational jury, having rejected attempted premeditated murder, could have found the defendant guilty of attempted manslaughter if correctly instructed. And this is not a new fact scenario. This is not a new case. This is a case in which this court, under similar fact scenarios, has concluded that the jury was deprived of a choice. Once the jury found the defendant not guilty of attempted premeditated murder, the instruction deprived the jury of a rational choice between attempted second-degree murder and attempted manslaughter. And attempted second-degree murder is a bit of an anomaly in Florida law. I've been doing this long enough to remember when it was an open question whether it existed as an offense at all. That was resolved in 2000, 4-3, in favor of its existence. But it's an oddity in that it involves an intent to commit a reckless act. And so, as I said, there's a very little difference between attempted second-degree murder and attempted manslaughter if correctly instructed. It is the depraved mind. And a rational jury, as this court found in Doherty, Williams, and the other cases, could have found that the defendant, because non-lethal force was used, because the weapon used was not designed to be used as a weapon, could have found that this was not attempted second-degree murder, that there was no reckless indifference to human life, and found attempted manslaughter. And I believe the reason this court has seen so many of these cases is because the manslaughter instruction and the attempted manslaughter instruction sends the jury back up to second-degree murder and attempted second-degree murder. It's very rare where the Montgomery error occurred where the jury found the defendant guilty of attempted manslaughter by intent to cause death. So, under this court's precedent, consistently from Montgomery, which was unanimous, on through to recent decisions.
And you agree that the foundation for Montgomery and all those decisions is a jury pardon doctrine, that a defendant has a right to a jury pardon?
No, I don't, Your Honor.
I mean, that's exactly what Montgomery says.
Yes, but
that's the foundation for this entire line of cases.
Look at the cases subsequent to Montgomery. And in many of the cases, in the majority opinions, in concurrences, justices have said that this is not a pardon power case. This is a case in which a jury, if correctly instructed, could rationally find the defendant guilty of manslaughter or of attempted manslaughter. This is no different from those cases. I'd like to move on to the second issue, if I can, which is waiver. And this court had the same certified question before it in Moore, had oral argument, discharged review. And Moore illustrates the appropriate test for waiver because there were two different errors in Moore. In the first, it was the Montgomery error. The trial court called counsel's attention to the manslaughter instruction requiring intent to cause death and offered to strike it. Counsel said it was okay. It came up several times. Opportunity was given. There was an intentional relinquishment of a known right because counsel said, yes, instruct this jury that manslaughter includes intent. This court said that that was waiver. However, the jury was not instructed on justifiable and excusable homicide as part of the manslaughter instruction. There was no discussion of that, and therefore that was not waived. And the First DCA reversed on that basis, and this court discharged review. Mr. Moore got a new trial. If the error is fundamental, as it always has been under Montgomery and Williams, waiver is required, and it just doesn't lie on these facts. There's been some discussion in the briefs and in the First DCA opinion about whether defense counsel had an incentive to let the jury hear the erroneous instruction that conflicts with the defense theory of intent to kill. There's no reason why defense counsel would have allowed the jury to conclude that the defendant intended to cause the death and therefore found him guilty of attempted manslaughter. And the First DCA...
So your position would be that the trial counsel was ineffective for failing to note the erroneous jury instruction and correct it?
Yes, Your Honor. We didn't raise ineffectiveness because at the time the case law said that this was fundamental error. But yeah, this is going to be ineffective assistance of trial counsel, as it has been in other cases. We've even had ineffective
Wouldn't you agree
assistance.
that under Sanders and that line of cases, the defendant would not be entitled to relief in an ineffective assistance counsel claim?
No, because the prejudice would be the same as the prejudice that I'm asserting here, which is that a rational jury could have found him guilty
I mean, no, they,
of attempted manslaughter if
I think
correctly
Justice
instructed.
Cantera wrote in Sanders that the jury pardon doctrine cannot support a finding of prejudice. Isn't that correct?
Yes, Your Honor. Yes, Your Honor.
Okay.
But here we are in direct appeal, and we're on discretionary review from direct appeal. And the reason you want to address this on direct appeal is because, number one, that resolves the error as soon as it's discovered, as soon as it's brought to light. And you wait until 3850 proceedings, you get a new trial then, witnesses' memories have failed. And if you wait to 3850, defendant does not have a right to appointed counsel. A lot of these defendants are borderline competent, illiterate, will not file a viable Rule 3850 motion.
Well, but it's just to clarify this, if you were to lose on the first issue, I'm not saying you will, but if you were to lose on the first issue, that'd be the end of this. There'd be no 3850 on that issue.
Yes, Your Honor, that's correct. I need to win on both issues. You're right, Your Honor. But consistent with this court's case law, both on the waiver and on the prejudice, this defendant is entitled to a new trial. And I'd ask the court to vacate the decision of the First DCA, answer the certified question in a way that demonstrates that waiver did not occur here, and that this was prejudicial and harmful because a rational jury, if correctly instructed, could have found the defendant guilty of attempted manslaughter. I'll save the remainder of my time for rebuttal.
Good morning. May it please the Court. Caitlin Weiss from the Office of the Attorney General on behalf of the State of Florida. Your Honors, this is a case with three interlinked issues: the issue of waiver, the issue of fundamental error, and the pardon power. We've reached this point with the issues of waiver and fundamental error because of the expansion of the pardon power doctrine. And one of the issues in this case was the certified conflict with Carruthers on the meaning of Dean. It's the state's position that Dean abrogated the pardon doctrine, which resolves the other two issues in this case, specifically the issue of waiver and the issue of the application of fundamental error doctrine. So it's the state's position that in Dean, three justices, Justices Lewis, Kennedy, and Lawson, found that manslaughter was a Category 1 lesser included offense of second-degree felony murder, and affirmed, explicitly incorporating Justice Polston's conclusion that the pardon doctrine would be used to affirm the decision. With the abrogation of the pardon doctrine, you're left in this case with the fact that the error in the lesser is no longer fundamental, and that the verdict of guilt on the higher offense, which was strongly supported by the evidence, renders the error irrelevant because the jury found beyond a reasonable doubt those offenses in the higher. This resolves a key issue in the current case law with the waiver. The fact that the state of the law with waiver does not take into account the doctrine of invited error. As the law stands now, this is a case where a defense attorney was given a copy of the jury instructions on the first day of trial, where he reviewed them, came to court the next day and said that he had no objection, Judge. I did read through these last night, and I didn't really have a problem with any of the instructions. The instructions were then discussed 4 times over the course of the day, with the defense attorney consulting with his client and making substantial alterations to those instructions. So it's really the state's position that the issues in this case can be approached a number of ways.
Putting aside the Dean issue for a moment, if there was a plea colloquy and the plea, one has a number of rights before they waive a plea. If the plea colloquy said no more than, Judge, I waive all my rights, and there was no discussion of what all those rights were, would that be a sufficient plea colloquy if it was later challenged that the defendant was not advised of certain specific rights?
I don't think that that would be sufficient,
right.
But I think that...
Isn't that largely because it has to be a knowing, intelligent, and voluntary waiver of one's rights, and for that to be the case, one has to know what those rights are? Isn't that the basis of that, of why it's not sufficient?
That is, and if you apply, the way that definition has been applied to waiver, so you're applying that definition to a defendant being questioned about his rights.
I am.
In this situation in waiver, you're applying that to a defense attorney.
Yeah, but
and you're assuming that they're ignorant of the law.
Well, it looked a lot like everyone in the room was ignorant of the law. And by the way, I want to be clear, although I was not on the trial bench afterwards, many good trial judges who I know of made the same error, because the standard instructions that this court had specifically blessed, which is a whole separate problem, allowed this to happen. So I don't, there's no...
That was a much different court.
You got that right.
I can assure you that won't happen anymore. But no, these things, it happened. And my point is, how can we say without a specific discussion of the exact issue that it was knowing, intelligent, and a voluntary waiver, which is what one has to be in order to be an actual recognized waiver?
Well, I think then you apply the test proposed by the First District in the Knight opinion. You don't assume that defense counsel is ignorant of the law, because that flies in the face.
But then you're putting an extra burden on defense counsel when the ultimate person who's responsible for charging the jury correctly on the law is the trial court, correct?
But on the contrary, if you assume that a defense attorney is ignorant of the law, then you put an extra burden on the state to prove that every time the defense attorney says, yeah, I'm okay with these jury instructions, you'd almost have to force the state to conduct a mini Ferretta inquiry of a defense attorney to say, hey, are you sure? Did you really read them? Do you know the law? And that's an irrational result.
In this case, the state attorney in this case also was ignorant of the law. Everyone was ignorant of the law
Exactly.
in this case, but the law had just changed in terms of even the standard jury instruction on this, I think, had just been revised a month prior to this actual trial.
The instruction was new, but the rule was not. Everybody, this was a public issue for years before this trial.
I understand that, but the reality is that trial court judges are going to be very wary of doing anything other than a standard jury instruction. And up until a month prior to this trial, the standard and jury instruction on this charge was still the one that they gave. So no trial court judge is going to deviate from a standard jury instruction.
I think that there is no doubt in this case that everybody made a mistake about what instruction was used. But I think that you have to look at the fact that
how do you have a knowing waiver when there is no discussion and on judge or the trial court himself saying, maybe this is, I understand this is a standard jury instruction, but I've read the cases and this is not correct. And I think that we should revise the standard jury instructions to reflect what I believe is a correct and accurate reading of the law.
There's two answers to that question. The first is that this court has to recognize that the only person in that courtroom that benefits from an error of this nature is the defense. And while it's undoubted that everybody in the courtroom made a mistake, the person that benefits from it is the defense.
That's not really true, right?
Absolutely, it's true.
The state benefits from it by having the higher burden there on a lesser included offense so that it falls maybe somewhere else, doesn't it?
But under the state of the law right now with this...
Am I right?
Well, I don't think so, because it's error built in.
If the same intent and voluntary, which is the third on the chart, is the same as the first on the chart, then you get the middle, right? Isn't that
But I think
not exactly what the defense is saying happened here?
But when you...
Am I right?
You're correct,
Okay.
but there's...
So the state benefits from it, doesn't it?
I don't think that the state does, because when an error of that nature is pointed out on appeal under the current case law now, where it's fundamental and essentially entitles the defendant to a new trial, the state is then faced with the Herculean task of reassembling all their witnesses, particularly in a domestic violence case. That is not easy. And bringing them back and retrying the case.
But under the rule you're proposing, the state would benefit.
If you abrogate the pardon doctrine, the state would benefit in this case, yes. And frankly, it would be appropriate on a number of levels given the evidence.
I'm talking about if under the rule you're advocating about waiver.
Oh, about waiver.
About waiver, if we adopted that, then the state actually would benefit.
Not necessarily.
If you go back to my hypothetical for a moment, so imagine a defendant, he's active, So this is his fourth plea colloquy. The other three, he's been well advised of his rights. He has knowingly waived them. In fact, he even represented himself after Ferretta at the last go-around. He's that good. So he's here for round number 4, and the plea colloquy simply is, you understand your rights? Yeah, I've been here before, Judge. I waive all of them. And that's it.
That's not sufficient because you're talking
Why?
to a defendant.
But it's someone who clearly knows the rights. In fact, they even acted as their own attorney the last go-around.
We treat so under your hypothetical, we treat defense attorneys the same as defendants.
But isn't a defense attorney a spokesman for a defendant, especially in the context of waiving one's rights?
But the defense attorney has gone to law school, passed the bar, and been practicing law, is governed by the rules of the bar that force him to have a knowledge of the law. You want to apply the same rules to a defense attorney for a defendant, and I can think of so many ways that would ricochet through the trial process.
Well,
The system proposed by...
I still have a problem because, you're putting a higher burden on defense counsel than you are on the state. And there is no reason. They're both officers of the court, correct? So they're both entrusted. If you have a case that is opposite or harmful to your position, it's your obligation to bring it to the court's attention. So, that goes both ways. So to me, this concept that defense attorneys have some higher burden, that they have to be all knowledgeable, when the standard jury instruction was, until a month prior to that, the standard jury instruction that was actually given, is sort of perplexing to me.
Well,
and in addition to that, this whole concept of the First DCA, that there's some strategic reason for defense counsel to do this, I know a lot of defense attorneys in Miami, and that's not what they do. They want to have a good trial and they want to get it done right, and that's not what they do.
I don't assume that every defense attorney does. I was also a trial attorney in Miami, and this court has a doctrine of invited error. It has recognized
How is this
in the
invited
past,
error? This is not invited error. How can it possibly be invited error?
It's the same concept as invited. The concept of sandbagging essentially stems from the concept of invited
Let me
error.
just ask, as Justice Luck pointed out earlier, doesn't the invited error doctrine require relinquishment of a known right?
Yes, and what the
how can you say that this was a known right when we've already talked about the fact that it appears that no one in the room knew that this was a problematic instruction?
I think that what the First DCA's analysis on this point does is interjects a series of factors to look at to determine if the right was known. It changes the analysis on that point. And that standard of analysis takes into account the possibility of sandbagging, how long the instruction was in place. The state is not trying to prevent, the state is trying to equalize this system and allow waiver to be found when the circumstances support it. The instructions were discussed over days, 4 times. The defense attorney read them overnight.
And 4 times, the trial court and the prosecutor read it, and nobody found a problem.
I agree.
And why didn't the state correct it?
Because obviously everybody in this room made a
Was
mistake.
the state trying to sandbag, or what's it?
The
it
state
seems that
has
you're
no
imputing.
interest.
It seems that part of the analysis here is to impute this sandbagging motive based on knowledge to the defense, but yet the state is there clueless. And if the state can be innocently clueless, why can't the defense be innocently clueless?
They certainly can, and in that case, these factors would hopefully sort out who was innocently clueless and who was doing it purposefully. And I think that you have to acknowledge in a situation with waiver like this that the person that benefits from this mistake is the defense. And that's why this waiver analysis is necessary. However, I will point out that this court, again, does not have to reach this issue of waiver if you address either the application of fundamental error or the issue with the pardon doctrine.
If you had to pick, so let's say there's 2 things wrong here. There is how we've read fundamental error in this context, different than any other context that I can tell we've read fundamental error, or getting rid of the pardon power altogether, and assuming your opposing counsel's right that Dean didn't do that already. Which one would you pick?
I think eradicating the pardon power takes care of fundamental error in this issue and waiver. So I think if you abrogate the pardon power, what you're left with is the fact that the jury's instructed, assuming as in this case there's an error in a lesser but a conviction on the higher, any issue with the lesser must be preserved, would go back to being subject to the contemporaneous objection rule, and could be challenged on direct appeal. And the verdict of guilt on
Doesn't changing the fundamental error issue take care of that? In other words, the standard rule is unless it vitiates the trial. I mean, I think you both do a good job of that in your brief discussing the normal standard. For some reason, somewhere down the line, we've essentially said that this is reversible per se, which is not the concept of fundamental error.
Yes.
So here, as we've talked about, the facts don't seem to support anything other than, or it'd be really hard for them to find, such that it'd be hard to say that it vitiates the trial, that there was a mistake somewhere down the line for evidence that doesn't seem to support that. Wouldn't that be an easier way to take care of this problem and reserve for later the much harder discussion of whether to do away with a right that may be implicit within the right to a jury trial?
I agree. I think there's several levels of solution to this case. I think that is kind of the middle level where I guess it's kind of abrogation light of the pardon power, where you say that an issue with a lesser still must be preserved, but a non-preserved error in a lesser is not this hybrid per se reversible fundamental, but the burden is on the defense to show that it genuinely vitiates the trial. So yes, I think that is
Which is true of any other
possible
preserved
solution.
error throughout all of
Yes.
criminal jurisprudence, right?
Yes, and I think the misapplication of fundamental, the kind of merging, I think, with per se really happened with Abreu, which was preserved, and we've kind of applied that preserved standard now to unpreserved errors. And I think that is a potential solution. However, I think that, though, leaves in place the problems with the pardon doctrine, which is not based in anything but case law and has really ballooned and been expanded to provide protections.
Let me ask you another question. You mentioned per se reversal rules, which are very different from fundamental error.
Very,
right?
yes.
So a per se reversal rule would apply if the court said it applied, so that if the defense counsel did object and say this requires intent and it should not require intent, and we have a right to be instructed on all necessarily included lesser offenses correctly. So say the defense counsel had waived the objection. Would you say the per se reversal rule should apply, or the normal harmless error test?
So I think that depends on what you do with the pardon doctrine.
Assume we get rid of the pardon doctrine.
Okay, so assuming you get rid of the pardon doctrine, so I think that the basis for the per se reversible is Abreu, which is based on the pardon doctrine. So say your pardon doctrine's out. Under that circumstance, I think it would revert to a harmless error analysis. It's preserved.
Isn't that the problem? If we do away with the harmless error analysis, then if we do away with the pardon doctrine and there's a proper objection, then any error would be harmless.
No,
as a
it
matter of
would
law,
fall
because
to
the
the
defendant-
state then to prove. If you apply the harmless error properly, the harmless error burden would then fall to the state to prove that the error was harmless. So
How would they
certainly-
do that if we say that you can't get a reversal based on the theory that you might have gotten the pardon to a lesser offense?
I think it becomes infinitely harder.
Impossible, I would say.
I think that, though, is why it would cure the issue of invited error. Defense counsel would have to object to really preserve the issue or make it appealable. But yes, it would make it harder, but that...
I mean, isn't that the very purpose of a per se reversal rule, so that if a knowledgeable defense counsel does properly object, and there is no way to show prejudice, but the trial judge gets it wrong anyway, that the defendant can get a new trial if there's an objection where you cannot show prejudice. I mean, there are just some circumstances where you cannot show prejudice, and I would think if we did away with the jury pardon doctrine, you could not show prejudice here as a basis for
and I
reversal.
think that that's the whole point of the pardon doctrine. The basis of the pardon doctrine is that when you find guilt on the higher offense, you assume that the jury, based on, that conviction is based on substantial evidence. You know that the jury found beyond a reasonable doubt the elements of the crime. And giving the jury the power, to presume that the jury would have found something else, that's the fundamental principle of the pardon doctrine. And so when you eradicate the pardon doctrine, you eradicate that speculation.
The counsel isn't part of the answer that it depends on the evidence, and if it's a case where the evidence is strong for one and very weak, if non-existent, as to the other, then it's very easy to overcome the harmless error standard, assuming there had been a preserved objection. But in a case where it's flipped, where the evidence is really strong for the lesser and very, very slight, although the jury found it for the higher, then that could be seen as prejudicial, the failure to give that lesser included, would it
Yes,
not?
I completely agree. I think in this case, instead of standing over her with a pipe, beating her repeatedly, he hit her once and ran away.
Right, and she's an
different.
eggshell plaintiff for whatever, or
Yes.
an eggshell victim for whatever reason. But the jury, for whatever reason, found depraved mind based on some of the circumstances of the case.
Yes, I think that's an excellent point, and
So there is a role for harmlessness if we were to adopt a harmless error standard.
if you abrogated the pardon doctrine,
Right.
yes. If, again, properly applying harmless, the same way, we ask you properly apply fundamental, make the state prove the case, same in fundamental, make the defense prove that it vitiates. I think there
It's
is a role.
fact intensive.
Yes. And I think that's the whole problem with this case and with these doctrines, is that we've moved into per se decisions without analyzing the facts. And, at its core, there are a number of ways that you can resolve this. But whether you're looking at waiver or at fundamental error or at the pardon doctrine, this, it's really moved away from considering, did the error vitiate the trial? Is this so serious, that he should receive a second trial? And in this case, under any theory, the answer is no. So if there are no further questions, the state asks that this court affirm the First District Court of Appeals. Thank you.
Counsel, if you can answer a question for me. What does it mean in Dean when the plurality majority per curiam opinion says, we approve, quote, for the reasons expressed in Justice Polson's concurring opinion? What does that mean?
And, isn't there an and?
There is, but I'm asking about that portion of it. What does that mean?
That means that one of the two bases for the majority decision is the rationale.
Well, and means both, doesn't it?
And means both.
So didn't 3 judges agree to Justice Polson's and 3 agree to Justice Quince's?
That may be the breakdown. I'm not certain.
Or
Your
3, meaning the majority plus Justice Polson.
That could be, Your Honor.
So I count 1, 2, 3 plus 1 is 4, right?
I count 3 for abrogation of the jury pardon doctrine,
Well,
and 1 whose rationale you can't really determine. I don't think it really matters at this point if the issue is before the court today as to what the court did in Dean, because there is no majority opinion in Dean.
But if 4 justices agree to the rationale for affirming in the case, because it goes to the remedy in what happens there.
I simply don't believe that 4 justices did agree to that.
How else am I to read for the reasons expressed, we approve for the reasons expressed in Justice Polson's concurring opinion, which is joined by 3 judges in the plurality and then Justice Polston in his concurring opinion?
Because Justice Lewis signed on and he didn't sign on to the concurrence, and you have the additional and, which is the reasons in Justice
But he
Quince's
said
opinion.
he would affirm for both reasons in Justice Quince's and Justice Polson's opinions, right?
I understand. I don't discern from that a majority of this court for abrogation of the jury pardon doctrine. And abrogated or not, it doesn't matter in this case. It doesn't matter in this case because a rational jury could have found the defendant guilty of attempted manslaughter if correctly instructed. I understand that there has been a split of opinion on this court as to similar facts, but under similar facts, this court has said that the error was fundamental and reversible. And those decisions are entitled to the weight of precedent unless this court explains why that decision was either unsound in principle or unworkable in practice. I have good news for the court, which is I don't think you're going to see any more Montgomery cases at long last. I think this will be particularly good news for Justice Labarga. I think that all of these cases have worked their way through the system and that you're not going to see any more This is a thing of the past.
If we get one, can we come looking for you?
You can, Your Honor. I promise you, you can.
If we get one, I will come and look for you.
But they've worked their way through the system because this trial was in February of 2014. The pardon power is a very old vintage. I don't think you need to reach it in this case, but if you do, I would hope that you will explain to the people of Florida why it's no longer valid. Briefly, I'd like to discuss the two out-of-state cases that I submitted as supplemental authority. One is Flores. It's a Hawaii case, and this illustrates that other cases are applying the rational basis for a jury by a correctly instructed jury test, and that it is not peculiar to this court and these decisions after Montgomery. And then also the California case, which is Vasquez, which shows why under a similar fact scenario, the error would be harmful in this case. Unless there are additional questions, I'll conclude.
All right, well, we thank you both for your arguments today, and the court will now stand in recess for about 10 minutes. Thank you.
All right.